Abiodun.
We are ready, sir.
All right,
We are ready,
thank
sir.
you. Yes, thank you.
Record. Digital records. Stay in this meeting, consent to be anyone with access to the next record.
The judgment is ready. And this is the judgment of the court. I said this is the judgment of the court.
And the accomplices, sir.
Accomplices.
In the National Industrial Court of Nigeria, in the Akure Judicial Division holding at Akure before His Lordship Honorable Justice K.D. Damula, dated this 7th day of March 2023 in suit number NICN/AK/14/2020 between Mr. Adedeji Rotimi Adebayo claimant and Philips Pharmaceuticals Nigeria Limited defendant. Introduction. The claimant took out a complaint on 13th July 2020 and by an amended statement of facts via a motion filed on 31st December 2021, the claimant seeks the following reliefs.
Now, because we are just at ND, now we be this one. Now, supposed show for up again. Now we be at ND.
A declaration that the claimant is entitled to the salaries and allowances for the period of April 2015 to October 2015 before his appointment was forcefully terminated by the defendant. An order compelling the defendant to release the original particulars of the Nissan Maxima saloon car to the claimant. An order compelling the defendant to pay the claimant the sum of 10 million naira only as general damages for wrongful withholding the salaries, allowances, and original particulars of the Nissan Maxima saloon car that the claimant have finished paying back the loan. And D, 980,000 naira only, being the accumulated salaries and allowances from April 2015 to October 2015. E, the sum of 5 million naira only as cost of this action. The defendant filed a memorandum of appearance and a statement of defense, a counterclaim and a preliminary objection on 28th August 2020 and later amended sent by a motion of 16th March 2022, wherein the defendant counterclaims for 10 reliefs numbered as A to J. The claimant filed a reply and defense counterclaim by a motion of 2nd December 2020. You can actually put off your mic for now. You can put off your mic because I'm hearing you. If you cannot listen quietly, put off your mic. Case of the claimant is that he was employed by the defendant on the 1st day of July 12 as their medical representative with the following remuneration under listed below: basic salary 70,000, monthly expenses 85,000, monthly maintenance for the official car 15,000. It is his case that he was given a loan of 1 million naira to purchase a car, but that 100,000 naira was withheld for some other expenses. He bought the car for 750,000 naira, and the company compelled him to refund 150,000 naira. That he has finished paying the loan, but that the defendant has withheld the particulars of his car, that he has not been paid salary for some months, which amounts to like 7 months. the case of the defendant is that the 85,000 naira was daily allowances as he works, and then that he did not work for some months, and then that he has not yet finished paying the car loan, and it is on the basis of those allegations that the defendant counterclaims that at the time he was leaving, he was also owing the company some amounts of money. So the defendant counterclaims. The claimant filed a reply denying those averments also. And then final written addresses. Both counsels filed final written addresses and made submissions in favor of their client's case. Reference shall be made to any part of the written addresses as the need arises in the course of this judgment. Court's decision. A, preliminary objection of the defendant. The defendant raised a preliminary objection to the suit, contending that the suit is defective and incompetent, and the court lacks jurisdiction on the ground that the original process is incompetent and invalid in law for reason of failure to file same in Lagos Judicial Division, where the defendant has its head office and only office. The law relied upon by the counsel to the defendants is Order 2, Rule 11 of the National Industrial Code of Nigeria Civil Procedure Rules 2017, upon which the claimant counsel also relied in contending that this suit is competent. The claimant justified filing the matter in Akure Judicial Division on Order 2, Rule 11, submitting that the claimant respondent is jobless and he will not be able to afford going to Lagos in respect of this matter. Now, Order 2, Rule 11, Order 4, Rule 2, and Rule 3, then Order 5, Rule 5 and 6 of the rules of this court provide as follows. Rule 11, subject to the provisions of the Act on transfer of suits, an originating process in respect of a matter in which the court has jurisdiction shall be filed in any registry of the court nearest to where the defendant or respondent resides or has presence, or in which the defendant or respondent carries on business, provided that where economic, security, environmental, or other exigencies warrant, an originating process may be filed in the court's registry in a judicial division other than that closest to the place of residence of the defendant or defendants or respondent or respondents. Note 4.2, notwithstanding the provision of Rule 1 of this order, the president of the court may, in the interest of justice, fairness, balance of convenience, equity, and security of parties and the court, direct that a case be heard in a judicial division other than where the case was filed. Any matter filed in any registry of court may be heard in any judicial division of the court, as the president of the court may direct in line with Sub-Rule 2 of this rule. 5. Where a suit is commenced in the wrong judicial division, it may be tried in that division unless the president otherwise directs. 6. Where a party has reasonable grounds for a suit commenced in a particular judicial division to be heard in another judicial division, such a party or counsel to the party may apply to the president of the court to consider and give appropriate directives as to the appropriate judicial division in which the suit may be heard. A decision of the president of the court on such application shall be final. From the provisions of the rules, the following is clear. 1. A suit is to be filed in the judicial division where the defendant resides or has presence. 2. A suit may be filed in any judicial division where economic, security, environmental, or other exigencies warrant. 3. Where a suit is commenced in the wrong judicial division, it may be tried in that division unless the president otherwise directs. 4, the president directs at the application of any aggrieved party. The consequence, the competence of the suit is not affected by where it is filed. This is so because the Constitution, Section 254A, like Section 251, only established one national industrial court for the whole country and not one for each state as the state's high courts, Sharia Court of Appeal and Customary Court of Appeal as the states and federal of the states and federal capital territory. The entire contention of defendant counsel gives a picture of him considering the Lagos Judicial Division of this court as Lagos State Industrial Court and the Akure Judicial Division of this court as the Ondo State Industrial Court. There is only one industrial court for Nigeria, thus the name National Industrial Court, and the territorial jurisdiction of the court is Nigeria. Judicial divisions are only created for administrative convenience and the convenience of litigants. That is the spirit of Order 2, Rule 1. So the filing of an originating process in a judicial division other than where the defendant has its office of presence does not render the process incompetent, but the defendant has a right to apply for a transfer, which is subject to the discretion of the president of the court. Sorry. Okay. Sorry. There is only one industrial court for Nigeria, thus the name National Industrial Court, and the territorial jurisdiction of the court is Nigeria. Judicial divisions are only created for administrative convenience and convenience of litigants. That is the spirit of Order 2, Rule 1. So the filing of an originating process in a judicial division other than where the defendant has its office or presence does not render the process incompetent, but the defendant has the right to apply for a transfer, which is subject to the discretion of the president of the court. For all the above, the objection fails and is dismissed. Merits of the case. Having read the pleadings, evidence, and addresses of the parties, I am of the considered view that the two issues for determination are as follows. 1, whether the claimant has established his entitlement to any of the reliefs claims. 2, whether the counterclaimant has established his entitlement to any of the reliefs claims. The main claim, whether the claimant has established his entitlement to any of the reliefs claims. The claimant is claiming for salaries and allowances for the period of April 2015 to October 2015, a period of 7 months. The defendant admits that the claimant's salaries were withheld for the months of June 2015, July 2015, September 2015, and October 2015, but with a justification. According to the defendants, it is not true. I'm quoting the defendants now. It is not true that the claimant's salary for the month of April was withheld or stopped, as it was paid on the 28th day of April 2015. In addition, the May 2015 and August 2015 salaries of the claimant were paid on the 13th day of August 2015 and 9th day of September 2015, respectively. That the claimant's salaries that were withheld were those of the months of June 2015, July 2015, September 2015, and October 2015 as a result of inaccessibility to the claimant and his unavailability at work, poor performance as regards sales of products, and recovery of debts outstanding from the defendant's debtors. According to the claimant, that I could not sell, this one I'm quoting from the claimant. he said that I could not sell beyond 22nd of April 2015 because the defendant stopped invoicing products to her customers I was dealing with. That the only active transaction I had with the defendant was from January 2013 to April 2015. There is no reason on record not to believe the defendant that it paid the claimant salaries for April, May, and August 2015, and it is so found. Similar. Counsel.
Yes, sir.
Are you people listening?
Yes, sir. We are listening, sir.
Okay, but you don't know the traffic language of the court in judgment. That's their problem. When the court makes a finding, you said as the court pleases. It tells me we
are to, yes, sir.
Yes. Whenever I take an issue and I make a conclusion on it, the only way you can tell me you are with me is to say as the court pleases.
As the court pleases, sir.
As the court pleases, sir.
Thank you. Similarly, there is good reason from the admission of the claimant that the only active transaction he had with the defendant was from January 2013 to April 2015. The claimant cannot justify his claim for the months of June, July, September, and October 2015, and the claim fails and is dismissed.
As the court pleases.
As the court pleases.
The second prayer is for the release of the originals of the card documents having completed the loan repayment. It is agreed by parties that out of the 1 million naira, the car was bought for 750,000. 100,000 naira was retained for other services on the car loan, and 150,000 was returned, making the claimant liable to repay 850,000 naira. The claimant did not say when the monthly deductions of 35,000 naira started, but the defendant said it was from September 2013. So be it. Now, the claimant was in service up to October 2015. From September 2013 to October 2015 is a period of 25 months, out of which the claimant was adjudged not entitled to salaries for 4 months. The monthly deductions was 35,000 naira, meaning the defendant is admitting making 35,000 naira deductions from the claimant's salary for over a period of 21 months, which will amount to 35,000 times 21 equals to 735,000. I find that the outstanding loan repayment is 750,000 naira minus 735,000 naira, which is equals to 15,000 naira. The claimant is entitled to the original documents of the car upon payment of the balance of 15,000 naira to the defendant, and that is the extent to which claimant's case succeeds.
As the court pleases.
As the court pleases.
As the court
The
pleases.
counterclaim. The counterclaim. The counterclaim. Whether the counterclaim claimant has established his entitlement to any of the reliefs claimed. The reliefs in the counterclaim, though overstretched, are basically for the sums of A, 586,850 586,850 naira being admitted indebtedness. B, 1,735,850 naira outstanding liability of the claimant to the defendant. C, 710,000 naira outstanding car loan. There is no concrete explanation and calculation or proof of how the sums of 586,850 naira is arrived at. For what? For what and what? Except for the fact that the claimant is said to have acknowledged it on a minute of meeting of 1st August 2015. Similarly, the basis for the claim for the outstanding of the sum of 1,735,850 naira against the claimant for what and how did the defendant arrive at the calculation is not disclosed. The justification for this claim, according to the defendant, is that the claimant counter-defendant was not able to disprove the claim on the document accepting the resignation of the claimant dated 1st August 2015. In the first place, if the letter of acceptance of resignation stated the claimant's indebtedness to the defendant, that alone will not amount to proof before the court, even where the claimant did not respond. The defendant counter-claimant still has the burden of proving by concrete, believable, and acceptable evidence how comes about the indebtedness and the amount. This has not been done by the defendant counter-claimant. I have seen Exhibit CWC, the letter of acceptance of resignation, dated 1st November 2015. Of relevance are the second and third paragraphs, which read as follows. Please note that you are yet to balance your final settlement of the company car with vehicle registration number LND 877BP, which you are paying in installments. We would like to use this opportunity to remind you that you are indebted to the company with the details enclosed as your outstanding balance from your sales while you were with Philips Pharmaceuticals Nigeria Limited. The letter did not state how much was outstanding on the car loan. It did not state how much was outstanding as outstanding balance from claimant's sales while he was with the defendant. Reference was made to enclosed details, but the enclosed details is not in evidence. In any event, disclosing these figures in the letter and tendering the enclosed details would not discharge the need for proof by evidence before the court, which the defendant has not done. The claim for 710,000 outstanding loan as the difference between 850,000 and 140,000 naira is a strange and pitiable mathematics by claimant counsel in view of the pleadings in paragraph 17 of the statement of defense and counterclaim that the claimant did not finish the repayment of the car loan as there were some months that the defendant did not pay the claimant for not working. In the months of June, July, September, and October 2015, the claimant was not paid and therefore deductions were not made. The repayment plan for the car loan was to run for 26 months, that is from September 2013 through October 2015. There were no payment of salaries and monthly expenses in the months of June, July, September, October 2015, and this ran into about 140,000 naira from the actual amount of 850,000 naira to have been paid by the claimant. So you see that here, there is acknowledgement that the amount to be paid was 850,000 naira, but for 4 months he was not paid, so no deductions was made. That amounts to 140,000. So going by this, the claim should be for the sum of 140,000 naira being the difference or the differentials between 850,000 and 710,000, and not the other way round as claimed. In any event, adopting the findings already made in the course of this judgment, the outstanding loan payment is 15,000 naira. As to the alleged admitted outstanding of 586,550 naira said to be admitted and signed by the claimant in the minutes of the meeting of 1st August 2015, Exhibit TS3, I find at the second page of the document the following entry, and I read. what has been your outstanding, Rotimi? 2,000 naira. Modi Mundi, that is Modi Mundi was the one who responded. 222,000 naira. Matendra, can you confirm the outstanding of Rotimi? And this is the response of Matendra. 883,850 naira. Then in handwriting and unsigned, this is what is written. After recalculation, the figure 586,850 naira. Now there are two figures and an unsigned handwritten figure. Rotimi himself did not answer that question. Why has the defender not chosen 222,000, but an unsigned handwritten figure that amounts to mutilation of document is not clear? The signature of the claimant on this document only goes to confirm that he was at the meeting and not the admission of his outstanding, which is not even made clear in the document, as there is no reason not to interpret it as outstanding owed the claimant by the defendant as against outstanding owed the defendant by the claimant. The need to plead how the defendant came about the conclusion that the claimant is owing it, whatever sum for whatever, is not done away with by the fact that the claimant signed the minutes of the said meeting.
As accomplices.
As accomplices.
As accomplices.
For all the above, the counterclaim succeeds only to the extent that the claimant is to pay to the defendant the sum of 15,000 naira before the original particulars of the vehicle be released to him, and it is so ordered. Court orders.
As accomplices.
For the avoidance of doubt, the court orders as follows. The claimant is hereby ordered to, within 2 weeks of this judgment, pay to the defendant the sum of 15,000 naira, being the outstanding balance on the car loan. The defendant is hereby ordered to immediately release to the claimant the particulars of the vehicle upon receipt of the payment of 15,000 naira from the claimant. This is the judgment of the court, and it is entered accordingly.
As the accomplices.
Thank you.
We are grateful, sir.
We are grateful, sir.
The judgment will be ready for collection today.
As accomplices, sir.
We are grateful, sir.
We are grateful, sir.
Thank you.
Please, damn it.
When you were not listening.
All right, thank you, gentlemen.
Thank you, sir.
We'll call the next matter for judgment. And the next judgment now. We have just read Adebayo, right? Yes. Adejumo. Adejumo. Adejumo Muritala Ishola.
Yes, my lord. Present, my lord.
That's NICN/AK/02/2020, right?
As accomplices.
Okay. Is your client online?
No, it's the Adejumo is not even online. It is Jimo Sani, the candidate that is my client is not online.
Appearances.
With profound respect, my lord, S.O. Jimo. My appearance is for the claimant, my lord.
Eh? Who? Who appears with you? Your sound is not coming. Are you far from your mic? Okay. And who?
Jennifer Okwe.
Okay. Okay, Jennifer. You are for the. Thank you. Okay, the case is for judgment. And this is the judgment of the court. Are we together?
As the court pleases, my lord. We are with your lordship.
That is how we know we are together. In the National Industrial Court of Nigeria, in the Judicial Division holding at Akure, before His Lordship, Honorable Justice K.D. Damlak, dated the 7th day of March 2022, suit number NICN/AK/02/2020 between Adejuma Muritala Ishola Clement and 1. Globalcom Limited, 2. Contact Center Service Limited, defendants. Okay, yes, Sorry, let me make the corrections on the appearances right away. Yola. Judgment. Introduction. The claimant took out a complaint against the defendants on 20 January 2020. The defendants filed a memorandum of appearance and a statement of defense and counterclaim via a motion of 16 June 2020. The claimant amended his statement of facts through a motion of 18 October 2021. The defendant filed a consequential amended statement of defense and counterclaim on 24th November 2021. The claimant seeks the following reliefs. A, the sum of 1,335,000 naira being arrears of unpaid leave bonus accruable to the claimant while in the service of the defendants at the rate of 445,000 naira per month, being equivalent to the last salary he earned in the service of the first defendant. B, per diem allowance from 3rd March 2011 to 27th August 2018, being 2,759 days at the agreed rate of 125 per day. This is equal to $334,775 United States dollars only. Please, you are talking in the chambers is interrupting. Sum of 14,400,000 naira as terminal benefit based on policy and practice of the first defendant, less the sum of 1 million naira, 8,250 naira already paid. D, an order for payment of the sum of 5 million naira compensation for the unlawful, oppressive, enslaving, and unconstitutional clause preventing the claimant from taking up employment in any company in the same line of business with the first defendant in the contract of service offered the claimant by the defendants, coupled with the refusal to pay him his dues as amounting to an unfair labor practice and therefore against international best practice in labor, employment, and industrial relations. Case of the claimant. The claimant filed a complaint on 20th October 2020 and amended his statement of facts through a motion of 18th October 2021. But on 9th March 2022, when the claimant testified, he adopted both the witness depositions of 20th January 2020 as well as that of 16th October 2021. The law is that the process of 20th January 2020 is no more extant, having been replaced by the amended process of 18th October 2021. For this, only the witness deposition of 18 October 2021 and the reply deposition of 10th January 2022 shall be considered herein. According to the claimant in his witness deposition of 18 October 2021, adopted on 9th March 2022, it is his case that the first defendant is a private limited company who is one of the leading operators of mobile communication services in Nigeria, which is a corporate office at 54 Saka, Tinubu Street, Victoria Island, Lagos State. The second defendant is a subsidiary or sister company to the first defendant. It's also the staff recruitment company for the first defendant with his corporate head office at 18A Akure Close, Victoria Island, Lagos State, and one that recruited the claimant for the first defendant. That I was employed via a letter of employment dated 7 July 2006 by the second defendant on the instruction of the first defendant as executive officer grade 1 step 1 in the first defendant employment and was mandated to resume work on the 10th of July 2005, which I did accordingly. That I resumed work with the first defendant on 10th day of July 2006 in the said capacity and remained in the employment of the first defendant throughout in different capacities and in different cadres till the 27th of August 2018, when the first defendant directed me to return to Nigeria from first defendant subsidiary Glo Mobile Ghana in West Africa, where I was unceremoniously transferred to on the 18th of February via an internal memo. It is the case of the claimant that he was entitled to some benefits as an expatriate, just like his other foreign expatriates. He was entitled to per diem of 250 per day, but it was negotiated to 125 per day, that he was paid only for the first 2 weeks and never paid again. He was entitled to accommodation. He was not given accommodation. And those are the basis of the claim. Some other basis of the claim will be considered in the course of the judgment. It is his case that aside his outstanding salary and the sum of 1,908,250 tax terminal benefit, no other sums have been paid to me till date, that the provision in the contract of employment of the parties barring me not to work with any company in the same line of business with the defendant for 1 year after disengagement is enslaving, oppressive, and unconstitutional. That the first defendant is owing me per diem arrears for 2,759 days, amounting to a sum of $344,875 US as per diem allowance for the period between 3rd March 2011 to 27 August 2018 at the agreed rate of $125 per day. The defendants filed a statement of defense, and the defendant denied all the allegations and gave its own side of the story. And it is the case of the defendant that he is not owing the claimant anything. The defendant also counterclaim for the sum of 1 million naira being the amount paid to claimant defendant to counterclaim in error by the defendant's counterclaimants in lieu of notice. The sum of 890,000 naira being the equivalent of 2 months' salary that the claimant counter-defendant. Okay, that the claimant stroke defendant to counterclaim ought to have paid to the defendant's counterclaimants in lieu of notice upon his immediate resignation on 27 August 2018. Cost of this action fully indemnifying the defendant's counterclaimants. The claimants filed a reply and a defense to the counterclaim denies all the allegations of the counterclaimant. In the defendant's final written address, which carries the legal stamp of Iyola Afolabi, but none of the listed four councils' name is ticked to indicate who signed the written address. 3 issues are formulated as follows. A, whether the claimant has sufficiently proved his case to be entitled to the relief sought in this suit. B, whether this honorable court is bound to follow the decision in suit number NICN/ABJ/22/2018. C, whether the defendant's counterclaimants are entitled to their counterclaim. Counsel answered the first 2 questions in the negative and then answered the 3rd questions in the affirmative. Reference shall be made to any part of the address as the need arises in the course of this judgment. Claimant's final written address. In the undated claimant's final written address, which carries the legal stamp of Saliu Ojo Jimo, but none of the listed 4 councils' name is ticked to indicate who signed the written address. 3 issues are formulated as follows. Whether or not the claimant is entitled to payment of per diem in lieu of accommodation and basic necessaries as employee sent to foreign country as an expatriate. B, having regards to the admitted evidence before the Honorable Court, whether the claimant is entitled to the other relief sought. C, whether the defendant counterclaimants have sufficiently proved their counterclaim to be entitled to the relief sought. Counsel answered the first 2 questions in the affirmative and then answered the 3rd question in the negative. Reference shall be made to any part of the address as the need arises in the course of this judgment. Defendant counsel file a 14-page reply address. Reference shall be made to any part of the address as the need arises in the course of this judgment. Court's decision. Having read the pleadings, evidence, and final written addresses of both parties, the court is of the opinion that the defendant's first issue and the claimant's third issue are sufficient to dispose of this case, and they are hereby adopted as follows. 1, whether the claimant has sufficiently proved his case to be entitled to the relief sought in this suit. 2, whether the defendant's counterclaim has sufficiently proved their counterclaim to be entitled to relief sought. Before considering these issues, it is pertinent to consider two preliminary issues. The first issue is raised by claimant counsel, that the witness deposition of DW was not sworn before the Commissioner for Oaths. This is a violation of Section 13 of the Oaths Act and Section 112. I take it again. Before considering these issues, it is pertinent to consider two preliminary issues. The first issue is raised by claimant counsel, that the witness deposition of DW was not sworn before the Commissioner for Oaths, that this is a violation of Section 13 of the Oaths Act and Section 112 of the Evidence Act, that the deposition of the DW was also scanned and sent to the Commissioner for Oaths and not signed before him. Counsel contended that the deposition of DW2 be discountenanced and expunged. Learned counsel relied on the following cases. There are quite a number of them: Maria Plastic Industries Limited versus Inland Bank of Nigeria, no full citation. Senior Staff Association of UTHRT and AI, 2006-14 Nigeria Weekly Law Report, citation fully supplied. Adebola versus Osi, citation fully supplied. Buhari versus INEC, citation fully supplied. One Kolobi versus Ejemeli and other, citation fully supplied. In reply, the defendant's counsel submitted that by Section 42 of the Oaths Act, no irregularity in the form in which an oath or affirmation is administered or taken shall render inadmissible evidence in or in respect of which an irregularity took place in any proceedings, that by the authority of Honorable Rita Oji and another versus Independent National Electoral Commission and two others. Sorry, gentlemen.
As the court pleases.
That by the authority of Honorable Rita Oji and another versus Independent National Electoral Commission and two others, 2019 All Federation Law Report, Part 1025, page 343, at 400, the court held that a statement on oath which is adopted by the deponent after being sworn in the course of the proceedings would be cured if any defect in form will be cured of any defect in form when the declaration was made by the second oath taken before the court, and on the basis of it would be adopted by the deponent as his evidence in chief in the case. Such a statement on oath becomes the oral evidence in chief of the deponent after the adoption before the court, and so competent evidence which is admissible and to be assessed and evaluated in the determination of the case. The witness deposition of DW, though signed by the witness is not at all sworn by the Commissioner for Oaths. The witness, DW, adopted an unsworn statement. The court observed this and added the word unsworn in bracket when the DW2 referred to this deposition for the tendering of documents, and later in the course of recording the objection to admissibility of documents and response, the court had cause to call for counsel's copies of the DW's witness deposition and wrote in the record book in bracket that, and I put in here what was written on the record book in bracket. Court observes that even counsel's copies of the DW witness statement on oath are unsworn. The argument of the defense counsel is that it is cured by the oath taken before adoption of the witness statement in court by reason of the authority of Honorable Rita Oji. My Lord, Ogunwumiju JCA, as he then was of this same opinion in 2012 until in 2016. In 2012, this is what my Lord held in Udama and Arunsi 2012, 7, my dear will report, part 1298, page 55 at page 97 to 98. And I quote, "There is a distinction between affidavit evidence in proceedings by originating summons as against statement of witnesses on oath in an election proceeding in proceedings begun by writ. In respect of the latter scenario, where the written statement is to be adopted again on oath by the maker before his cross-examination on it, whatever defects in the original oath in respect of the witness statement has been cured by the second oath made in court before the judex prior to the adoption of the witness statement by the maker and his subsequent cross-examination." The court referred to Udeaga and Omegara 2010-11 Nigerian report part 1204-168 was referred to. However, in 2016, my Lord held in Onyeche Roku and another, forgive my pronunciation or murdering of the name, versus Jackson Nwabufo Eroku 2016 LPLR 41515 CA as follows. That's the same, my Lord, Ogunwumije JCA as he then was, now JSC. I had hitherto been of the view that even where the witness statement of the respondent at the trial court was not sworn to before a person duly authorized to take oaths in contravention of section 112 of the Evidence Act 2011, the subsequent adoption of the written deposition after he had been sworn in open court to give oral evidence regularizes the deposition. I was of the view that the witness statements which are adopted during oral evidence on oath are different from mere affidavit evidence which stand on their own without any oral backup and which are not subject to cross-examination. That it is such affidavit evidence which do not need the requirements of section 112 of Evidence Act that are intrinsically inadmissible. That where a witness is in court to say he or she is adopting an irregularly written deposition, the implication is that the witness is asserting on oath what is contained in the otherwise defective deposition, and such adoption on oath makes all the evidence in the written deposition admissible. However, that previous way of thinking must therefore give way to the opinion of the Supreme Court in Buhari and INEC 2008-12 SCNJ 1 at 91. In that case, the Supreme Court unequivocally agreed with the Court of Appeal's decision to strike out the deposition of the appellant's witnesses sworn before a notary public who was also counsel in the chambers of the senior counsel to the appellant, which was in violation of Section 19 of the Notary Publics Act and 83 of the Evidence Act, now Section 112. When a deponent swears to an oath, he signs in the presence of the Commissioner for Oaths, who endorses the document authenticating the signature of the deponent. Signature signed outside the presence of the Commissioner for Oaths fall short of the requirement of the statute, and such document purported to be sworn before Commissioner for Oaths is not legally acceptable in court. Quotation clause. However, the decision in Rita Oji is a 2019 decision. In making a general statement of the law, the court indeed made the statement relied upon by counsel, and the court relied on the 2012 decision of Ogunwumi JCA as he then was in Udama and Arunsi. That position of my lord was later to change in 2016 in Onyechi Eroku and another versus Jackson Nwabufo Eroku. The case of Rita Oji can be differentiated from the present case. In Rita Oji, an election petition, the facts of the case was that two witnesses wrote only the initials of their names on the witness statement sworn to. But in this case, the witness statement was not sworn. That is one difference. The ratio decidendi in Rita Oji is as follows, and I quote, in the case of statements on oath filed by the first and second cross-respondents along with and in support of their petition, they were competent and admissible in evidence when they were filed by them, since they bore, and the next lines are underlined, since they bore marks and alphabets of the particular deponents to indicate their respective makers, which satisfied the authorized person taking the declaration at the material time. The practice of coding the full names of witnesses in statements on oath to be used as evidence at trial of election matters, stroke petitions in Nigeria, usually for security reasons to protect their identity, has become recognized, accepted, and established by the election tribunals and endorsed by the appellate courts. All these are underlined. See Joseph versus Labour Party Supra. The fact that the INEC guidelines issued for 2019 elections required political parties to submit lists and names of their agents for the purpose of the election has nothing to do with the competence of statement on oath of witnesses to be used and relied on by parties in an election petition, so long as the person authorized to take or receive a declaration is satisfied that a declarant is sufficiently identified for the purpose of the declaration. From so long is underlined. It is so long as the person authorized to take or receive a declaration is satisfied that a declarant is sufficiently identified for the purpose of the declaration. The ratio descendant in Rita's case cannot be and is not an authority for saying that a witness statement not sworn to before a commissioner for oaths is cured by the swearing of an oath in the witness box before adopting the unsworn witness statement. The importance and efficacy of the oath in the witness box readily comes to mind when it is considered that the witness is to be cross-examined after adopting his already sworn witness statement. Learned counsels must be careful in relying on election petition cases for their general matters. Election petitions being sui generis. I take this again. I take it again. Learned counsels must be careful in relying on election petition cases for their general matters. Election petitions being sui generis. Counsel must first be sure that the ratio descendant in the case borders on generally applicable rule of law and not based on the sui generis nature of election petition, as is the case of Honorable Rita Oji and another versus Independent National Electoral Commission and 2 others. Citation supplied. For all the above, the objection succeeds and the witness deposition of DW not having been sworn cannot be used, meaning the pleadings of the defendants are not supported by evidence and deemed abandoned.
As accomplices.
The second issue is admissibility of the documents tendered by the defendant, which were objected to by the claimant counsel at trial on the ground that they were computer-generated documents and that there was no certificate of compliance as required by Section 84 of the Evidence Act. The response of the defense counsel is that the documents are all original documents from the claimant's file, that although they are all printed from a computer, they do not require certification. These documents were marked tendered and ruling reserved till judgment. I have looked at Exhibit OM1 tendered to OM7 tendered. They are documents usually produced by a computer in the course of official work. Such documents do not fall under Section 84 of the Evidence Act. Exhibits OM2 tendered to Exhibit OM7 tendered claimant's pay slips are indeed original documents as they carry original handwritten signatures. Such documents do not qualify as the computer-generated documents envisaged by Section 84 of the Evidence Act. The claimant does not contest the existence or correctness of the content of the pay slips either. Exhibit OM8 tendered is a copy of the claimant's resignation letter, also tendered by the claimant and marked as Exhibit AMI3. It is unclear the reason for objecting to the admissibility of this document. Exhibit OM9 is a calculation of the payment made to the claimant, which has been adequately explained in the pleadings and evidence, and which amount is not denied but first pleaded by the claimant. The reason for objecting to this document too is not apparent. For all the above, the objection to the admissibility of the documents tendered by the defendant is overruled. Is overrules and the documents are admitted in evidence and marked as Exhibit OM1 to OM9. Similarly, the defense counsel objected to the admissibility of a document tendered by the claimant on the ground that it was a photocopy and no foundation was laid. That document is a judgment of this court in suit number NICN/APJ/23/2018, a judgment of my Lord Hastrop J of the Abuja Judicial Division. The judgment is a photocopy of a CTC. The judicial authorities on photocopy of a CTC of a public document are conflicting. Luckily for the court, I am entitled to take judicial notice of the judgment of court and especially a judgment of this court. I hereby take judicial notice of the judgment in NICN/ABJ/23/2018 as delivered by my Lord House of J on 30th March 2019.
As the accomplices.
Merits of the case. On the merit of the case, we shall take each head of the claimant's claim and determine them under the mirror of the first issue for determination. But first, it is pertinent to note that although the pleadings of the defendants is deemed to be abandoned, this cannot and does not include the cross-examination by the defendant's counsel and the final written address, which remain valid and shall be so used. A, the sum of 1 million naira, 335,000 naira, being arrears of unpaid leave bonus accruable to the claimant while in the service of the defendants at the rate of 445,000 naira per month, being equivalent to the last salary he earned in the service of the first defendant. That the first defendant is still in arrears of 94 days of his leave allowance and has remained unpaid till date, which is the sum of 1,333,000 naira. The unpaid leave bonuses are conspicuously apparent on the defendant's enterprise planning software kept by the defendant's human resource strategy. Okay, sorry. I take that again. I take it again. The case of the claimant is that the first defendant is still in arrears of 94 days of his leave allowance and has remained unpaid till date, which is the sum of 1,335,000 naira. The unpaid leave bonuses are conspicuously apparent on the defendant's enterprise resource planning software, ERP, kept by the defendant's human resource department. The claimant did not lead evidence as to how he became about 94 days, and the defendant's enterprise resource planning software, ERP, is not in evidence. However, the claimant has admitted being paid the sum of 1,908,250,000 naira, though tax terminal benefit. This amount exceeds the claimant's claim. This claim therefore fails and is dismissed. Are we together?
As the accomplices, my lord.
Even if it doesn't please you, the requirement of our practice is that you must say as the court pleases.
As the accomplices.
As the accomplices, my lord.
And another importance of that is so that we know we are together.
As the accomplices.
Not for it to just keep quiet. Okay, claim B. You can switch off your mic a little. Claim B, per diem allowance from 3rd March 2011 to 27 August 2018, being 2,759 days at the agreed rate of 125 per day. I think it's $125 per day, but I'm writing it the way he put it. This is equal to $344,875. That's United States dollars only. It is the claim of the claimant that he was entitled to per diem at a negotiated rate of $125 per day throughout his stay in Ghana. The source of this entitlement is not disclosed, pleaded, or tendered in evidence. The defendant's handbook is not in evidence. There are no materials for the court to determine whether or not the claimant was entitled to per diem throughout his stay in Ghana. This claim fails and is dismissed.
As the accomplices.
C. Sum of 14,400,000 naira as terminal benefit based on policy and practice of the first defendant, less the sum of 1,908,250 already paid. This claim for terminal benefits is specifically against the first defendant. By Exhibit AMI1, the first defendant is not the employer of the claimant or the second defendant. And there is no document placed before the court, besides the fact that the first defendant pays the claimant's salaries, to warrant transfer of payment of terminal benefits of the claimant to the first defendant. The handbook of the second defendant or the first defendant is not in evidence, neither is the said policy. How did the claimant come about the sum of 14,400,000 naira is left to imagination, which is outside what the court can do. More so, by Exhibit AMI3 tendered by the claimant was the one who resigned his appointment, and that with immediate effect. The claimant has not placed any materials before the court to justify his claim for terminal benefits, let alone the amount claimed. Also, considering the case of Wayek and Felix, 2006-12 Nigeria Law Report, Part 994, page 258, the court held that tendering of a letter of resignation carries with it the right to leave the service automatically without any benefit, subject to his paying any of his indebtedness to his employer. For these reasons, the claim for the sum of 14,400,000 naira as terminal benefit fails and is dismissed.
As the court pleases.
An order for payment of the sum of 5 million naira compensation for the unlawful, oppressive, enslaving, and unconstitutional clause preventing the claimant from taking up employment in any company in the same line of business with the first defendant in the contract of service offered the claimant by the first defendant, coupled with the refusal to pay him his dues as amounting to an unfair labor practice and therefore against international best practices in labor, employment, and industrial relations. There is no doubt that there is a kind of tripartite employment arrangement between the two defendants and the claimant. This arrangement, however, is not easy to ascertain for the purpose of the rules of tripartite employment agreements. According to the claimant, the second defendant is a subsidiary and or sister company to the first defendant. It is also the staff recruitment company for the first defendant with its corporate head office at 18A Akure Walk Close, Victoria Island, Lagos State, and one that recruited the claimant for the first defendant. That I was employed via the letter of employment dated 7 July 2006 by the second defendant on the instruction of the first defendant as executive officer grade 1 step 1 in the first defendant's employment, and was mandated to resume work on the 10th day of July 2005, which I did accordingly. It is also the pleadings and evidence of the claimant that the provision of the contract of employment of the parties barring me not to work with any company in the same line of business with the defendant for 1 year after disengagement is enslaving, oppressive, and unconstitutional. Yet the first defendant refused to pay my deserved entitlements despite its unfriendly ban, which has left me jobless for more than a year. I would have secured an alternative employment if not for this clause in my contract of employment with the first defendant, as I am only fit to work in telecommunication companies, being a place I have been for close to 1.5 decades. Now, the claimant's letter of employment, exhibit AMI1, is from the second defendant, Contact Center Services Limited. The opening paragraph reads as follows, and I quote, "Following the discussion with you, we are pleased to offer you an employment in the company on Executive Grade 1, Step 1. The following terms and conditions will apply to your appointment." Then paragraph 13, non-competition. For a period of 1 year after the end of employment, you will not. Galaxy, please switch off your mic. Switch off your mic, Galaxy. For Samsung SM, for a period of 1 year after the end of employment, you will not control, consult, or be employed in Nigeria by any business similar to that conducted by the company, either by soliciting any of its accounts or by operating within the company's general business area in any telecommunications related business in Nigeria. We trust that you will be able to accept the challenge and opportunity of joining Contact Center Services Limited. Now, the pleading and evidence as well as the relief clearly show that the complaint is against the first defendant. From the claimant's letter of employment, exhibit AMI1, it is clear that the claimant's sole employer was the second defendant. Even though there is no secondment letter to the first defendant, it stands to reason that the claimant was not an employee of the first defendant, but sent there by the second defendant on whatever arrangement that has not been disclosed to the court. Clause 13 of the employment agreement is between the second defendant and the claimant, and so he cannot claim for unfair labor practice on that basis against the first defendant. Now, the second defendant is a party to this suit. But unfortunately, there is no proof that the employment relationship between the claimant and the second defendant has come to an end. Neither is this head of claim against the second defendant. I take it again. Now, the second defendant is a party to this suit, but unfortunately, there is no proof that the employment relationship between the claimant and the second defendant has come to an end. Neither is this head of claim against the second defendant. This is because the claimant was employed as a staff of second. I said this claim accordingly fails and is dismissed.
As accomplices.
Counterclaim. Having held that the defendant's witness deposition was not sworn and so incompetent and struck out, it follows that all the pleadings of the defendants are deemed abandoned for want of evidence and no relief can be granted without proof. Accordingly, the counterclaim is hereby dismissed for want of evidence.
As the court pleases.
On the whole, both the main claim and the counterclaim fail and are hereby dismissed. Each party to bear its cost. Each party to bear its cost. This is the judgment of the court and it is entered accordingly.
As accomplices. We are grateful, my lord.
Thank you. Now, this judgment will be ready for collection immediately. Will be ready for collection today.
I'm most grateful, sir.
Thank you. Did I tell the other people the first judgment? Okay. All right, thank you.
Thank you, my
We
lord.
go to the next matter.
You have a nice day.
Dr. S.O. Fatu Roti and 2 others versus Federal Ministry of Health and 3 others. AK 12 2022 appearances.
Humbly, your lordship, A.O. Ajayi is my name.
A.O. Ajayi is my name.
Yes.
With me is Pelumi Adegoke. With me is Pelumi Adegoke.
Yes.
Our appearance is for the claimant, my lord.
Yes.
May it please your lordship.
Yes.
Pere Ikuetemi. Pere is P-R-O-E. Pere Ikuetemi.
Yes.
Appearing with me is Awodeyi Folabi. Awodeyi Folabi.
Yes.
For the first and fourth defendants.
Okay. Second and third defendants.
My lord, I wouldn't know whether the counsel to the second defendant is online. I wouldn't know, sir.
Second defendant counsel, are you online?
In view of that, my lord.
Yes. No appearance.
No appearance. Thank you very much, my lord.
Yes.
With the greatest respect to your lordship,
yes.
Adekola Olawoye. And with me, for the third defendants, are my colleagues, B.A. Aderoshin, Esquire.
Yes.
V.M. Ekungba, Mrs. Ekungba is spelled E-K-U-N-G-B-A.
Is it VM?
Ekungba.
VM.
Milord, yes. VM.
Okay.
V for
okay.
Victoria, M for Michael.
Yes. Okay.
The last but not the least, my lord.
Yes.
Is C.C. Uzi. Izu, sorry. C.C. Izu means C.C. Izu. Izu is spelled I-Z-U. Miss.
For the third defendant.
We humbly announce our appearance for the third defendant. We are grateful, sir.
Thank you. Okay, just permit me a little while. Let me reflect this appearance on the judgment. Okay.
Yes, my lord.
Okay, sir.
Look at this.
For the A.O. Ajayi with Adegoke, isn't it?
Yes, my lord.
The retinue of lawyers that came for adoption are not there today.
They are engaged elsewhere, my lord.
Yes. Ajayi with P. Adegoke. For the claimant. Then
Yes,
Pere Ikwetemi for the first and second defendants, isn't it? Pere Ikwetemi, did you appear with anybody today? Olabi, yes.
Mute it.
No appearance. Pere, you are not holding his brief today. You are not holding brief for the second defendant today.
Mr. Perez, muted.
Third defendant. Okay. The matter is for judgment. The judgment is ready, and this is the judgment of the court. Suit number NICN/AK/12/2022 between Dr. S. Ofatu Roti, suing for himself and on behalf of members of Medical and Dental Association of Nigeria, Owo Branch, 2, Dr. A. Ojo, 3, Dr. A. N. Adedosu Clements, and Federal Ministry of Health, Attorney General of Federation, Dr. L. A. Ahmed, Mr. Loki Omoregba, sued on behalf of Federal Medical Center, Owo. The claimants took out an originating summons on 21st March 2022 with only the named claimants in their personal capacities, but later sought leave and amended the summons on 21st July 2022 to make the first claimant sue in a representative capacity. The summons is supported by a 29-paragraph affidavit, 1 exhibit, and a written address. In response to the various counter affidavits, the claimant filed further affidavits as follows. 1, a further affidavit on 12th October 2022 in response to the counter affidavit of the first and fourth defendants. 2, a further affidavit on 7 November 2022 in response to the counter affidavit of the second defendant. 3, a further affidavit on 13 October 2022 in response to the counter affidavit of the third defendant. The first and fourth defendants filed a counter affidavit on 19 August 2022. The second defendant filed a counter affidavit on 21st October 2022. The third defendant filed a counter affidavit on 2nd August 2022. The third defendant also filed a preliminary objection on 24th August 2022, in response to which the claimant filed a counter affidavit on 29 November 2022. By the amended originating summons, the claimant seek for the determination of the following questions. 1, whether the appointment or renewal of appointment of the third defendant as medical director of Federal Medical Center or having regards to the combined provisions of rules 160301, 160302, 020102, 010103, and 020205 of the Public Service Rules and the revised scheme of service for medical center, for medical officers, dental officers, and pharmacists in Nigeria, as well as the 1999 Constitution of the Federal Republic of Nigeria, is not wrongful, illegal, and void. Whether by the provisions of Rule 160302, 0710, 010112, and 020205 of the Public Service Rules and the 1999 Constitution of the Federal Republic of Nigeria as amended, the procedure for the appointment or renewal of appointment of the third defendant as the medical director of a Federal Medical Center or is not unlawful and illegal. The claimants then pray for the following reliefs: a declaration that the appointment or renewal of the appointment of the third defendant as the medical director of the Federal Medical Center or effective from 8 April 2022 is wrongful, illegal, and void. An order setting aside the appointment of the third defendant as the medical director of the Federal Medical Center or whose said appointment was communicated by the fourth defendant via a circular dated 7 February 2022 as wrongful and illegal. An order of perpetual injunction restraining the defendants, whether by or their agents or previous or through anybody, howsoever, from appointing the third defendant as the medical director of the Federal Medical Center or without following the laid down procedure. The reason for the relief of the cause of action. The reason for the relief or the cause of action as disclosed in the claimant's 29 paragraphs affidavit in support of the summons deposited by the third claimant is as disclosed in paragraph 7, 14, 16, 18, and 20 to 24. In particular, paragraph 23 is as follows. The renewal of appointment, the renewal of appointment or the appointment of the third defendant violates the public and the service rules and the revised scheme of service of the medical officers, dental officers, and pharmacists in Nigeria, which govern the employment of the third defendant, which govern the appointment of the medical director of the Federal Medical Center or and which governs appointments in the Federal Medical Center or because he gave reasons 1 to 15 reasons, chief of which are 3. The third defendant will be retiring in July 2022 upon the attainment of 60 years of age. The 4-year renewed term as medical director will make the third defendant a retiree medical director. For the third defendant to be qualified for appointment after retirement or when having retirement in view, the approval of Federal Civil Service Commission must be sought and obtained, which approval was not sought let alone obtained by the third defendant, of which are several reasons are given there. I have put them down there. The appointment of a retiree to head a government parastatal, that's paragraph 24, or a civil service organization like Federal Medical Center, or is unknown to the public service rules and the revised scheme of service of medical profession career. Counter affidavits of the defendants. The first and fourth defendants filed a counter affidavit on 19th August 2022. The second defendant filed a counter affidavit on 21st October 2022. The third defendant filed a counter affidavit on 2nd August 2022. I have read the counter affidavits of the defendants. Of particular interest is the objection raised by the third defendant on the grounds that facts giving rise to this suit are highly controversial, and as such, the appropriate procedure for commencement of same has not been followed by the claimants in instituting this action. On when an originating summons is suitable for the commencement of a suit, the Apex Court held in Standard Cleaning Services Company versus the Council of Obafemi Awolowo University, Ile-Ife, 2011, 14 Nigeria Weekly Law Report, Part 1269, page 193 at page 193 at 204 to 205 and 213 as follows. And I quote, originating summons should only be applicable in circumstances where there is no dispute on the question of facts or even the likelihood of such dispute. Application for initiating contentious issues of facts where the facts of the plaintiff leave matter for conjecture. Originating summons is not appropriate procedure. Where it is obvious from the state of the affidavits that there would be an air of friction in the proceedings, then an originating summons is not appropriate. Originating summons should only be used where the proceeding involve questions of law rather than disputed facts. Even where the facts are not in dispute, the originating summons should not be used if the proceedings are hostile. I have read the affidavits before me, particularly the claimant's affidavits in support of the summons and the three further affidavits of the claimant. I have read the affidavits and counter affidavits before me, particularly the claimant's affidavits in support of the summons and the three further affidavits of the claimants. The suit has all the features for which the Apex Court in the above cited case precedented that it should not be heard on the originating summons. In other words, there are disputes on the question of facts. There are contentious issues of facts. There is the likelihood of such dispute from the state of the affidavits that there would be an air of friction. From the state of the affidavits, there would be an air of friction in the proceedings. The proceeding involves not only questions of law, but also disputed facts and are therefore hostile. I came to the conclusion that it will be more conflicting to resolve the issues on affidavit evidence. The court is not at this stage supposed to analyze its reason or expatiate thereon, as these relate to issues to be determined in the suit, and this being a matter of discretion of the court. I exercise my discretion by ordering that this matter be heard on pleadings, and the parties are hereby ordered to file and exchange statement of facts and statement of defense accordingly. This is the ruling of the court, and it is entered accordingly.
As the court pleases.
As the court pleases.
Yes, what?
Are you muting it?
Yeah, talk about it.
My Lord,
Yeah.
I don't know what I'm heard, my Lord.
Yeah.
We're at this junction, my Lord. On behalf of the third defendant, we are grateful, sir, for your erudition and intellectual analysis of what the ruling the Lordship has just delivered. We felt as much from day one that the precious time of this court should not be wasted. But so far it has come away. We have no choice. We learn every day.
The thing is that by the procedure, we must take it all first before we still determine whether it should go to this level or not. So there is no way we could have just said, we could have just taken it rather than like this.
Thank you, sir.
Yes,
Thank
and
you.
it was after without delving into any this thing. It is when you find out that you cannot comfortably do so that you transfer it. If I could, based on the facts, based on the documents before me, resolve the contentious issues of facts, I would have proceeded. All right, so date. May, it was a May date. They have to file and exchange pleadings. So we have to give a date for hearing, isn't it?
Yes,
As the court pleases.
As the court pleases.
10th of May 2023 for
Pleadings.
Pleadings should be filed and exchanged.
That was what I ordered.
And yes,
that was my
and the rules of court of your Lordship stipulate time within which this thing should be filed and exchanged before
I
after the
presume that you
completion of
people know
pleading.
the rules, and that's why I didn't bother myself about giving you time limits.
Exactly. But I could hear
I
that.
didn't bother myself about giving you time limit because you know the rules.
We know.
Yeah.
So in that situation, my Lord, I don't know whether we are going to trial or I don't know what we are adjourning for now.
I said 9th May 2023 for hearing.
For hearing of the substantive suit?
Yes.
Yes.
As my Lord pleases.
Yes. Thank you.
Can we be guided, my Lord?
About what?
As to the convenience of this court, so this honorable court.
Convenience on what?
Yeah, convenience when it will be very, very convenient for your Lordship to hear us.
I adjourned the matter to 9th May 2023 for hearing. That's what I'm pronouncing.
As my Lord pleases.
9th May 2023 for hearing. That's my ruling.
As my Lord pleases.
Thank you.
Yes, my Lord.
Well, ladies and gentlemen, the ruling will be ready for collection today.
As my Lord pleases.
We are most grateful, my Lord.
Thank you. And that is the end of the proceedings for today. How do I go back?
Thank you very much.
I'm supposed to, when I just press like this, it should latch to the latch now. No, exit minimize video. Hide video, no, it should be this one. Okay, good. So gentlemen, we have come to the end of today's proceedings. You can actually leave. I am also going to leave.
Thank you very much, sir. I shall go places.
You're welcome.
Call DMD.
No, court. Okay, you can leave anything.
I've left.
He's not there. I am not going to be happy. Come
on. I don't really.